We're going to start up with our final session, and I will turn it over to Leah Waterland from Cisco Systems. Leah.
Thank you. Thank you all for your time this afternoon. I had heard a bad rumor that Judge Grewal was not going to be able to make it, but he is rushed to get here. So we have a wonderful panel today. Let me just briefly introduce everybody. I don't know if my brief introductions will give them justice, but I will try. I'll start with myself. My name is Leah Waterland, and I am a director of IP litigation at Cisco Systems in San Jose. And we manage a docket of worldwide patent litigation, but including what's turning out to be a pretty heavy IPR docket, both as a petitioner and defending quite recently. With us today on our panel, we have Ian Feinberg, who is a founding partner at Feinberg Day. Ian has more than 35 years of experience focused on patent, copyright, trademark, and trade secret litigation. He has extensive experience with motions to stay, which we'll be talking about today, pending inter partes review and CBM review as well. We have California Magistrate Judge Grewal, who was appointed in 2010. He serves as a member of the court's technology practice and patent local rules committees. He served as a law clerk to the Honorable Sam Bell of the Northern District of Ohio, and later as a law clerk to the Honorable Arthur Gallarza of the Federal Circuit Court of Appeals. And in private practice, Judge Grewal focused on IP litigation with an emphasis on patent trials and appeals. Clem Roberts is a founding partner of San Francisco litigation boutique Durie Tangri, and his practice also focuses on intellectual property litigation. He works on commercial cases as well, especially those that present substantial technology issues. And finally, we have Eliot Williams, a partner in the IP department of Baker Botts. He's located at the firm's Palo Alto office. And Eliot has been actively involved in PTAB trial matters since passage of the AIA, and he also testified on that topic before the House Judiciary Committee. So I'm very pleased to be moderating this panel discussion today. I hope that we have as lively a discussion as I just witnessed here right before. It was a really fun discussion, and I think while there's a little bit of overlap, our topic is very much on this panel to think about the coordination of district court litigation and some of these administrative proceedings. We welcome questions throughout, so please do not hesitate to jump in. Stand up if I don't see you and just wave me down, but we want this to be lively and interactive because it's the last session before the cocktail hour, so make it as fun as we can. I'd like to start with, I think, one of the most interesting topics that we were brainstorming about, which is stays of litigation. And I'm going to start with what might be a more basic starting point with Judge Grewal, but then we're going to go into the nuances because I think we're all seeing nuanced questions about stays popping up. But starting just initially, Judge Grewal, what are your views on stays of litigation pending instituted IPRs or CBM reviews?
Well, thank you. It's a pleasure to be here. I'm sorry I missed, well, the entire conference other than the last 3 minutes. Criminal duty in San Jose was rather intense today. Apparently, allegedly, there was significant criminal activity going on in the district. Fortunately, I was able to follow the entire events of the day in this room by opening up a tweet deck on my bench and looking for the right hashtag. On the subject of stays, I believe the question was, what do I think of them? And what do I think of motions for stay on instituted proceedings? The short answer is, it depends. The longer answer is that I think it is fair to say now that in almost every case that I see and that many of my colleagues see in our district, we expect to see motions for stay. In fact, it has now become such the norm that I am somewhat surprised when I get to the initial case management conference or at some intermediate conference during the pretrial phase and no motion has been filed and no mention has been made of a petition being filed at the PTO. So it is remarkable to me that it has been 2.5 years since the AIA was passed, and in that very short period of time, we've now come to see this as a matter of course in almost every case. I think in terms of the fact that a proceeding before the board has been initiated, I think that fact is obviously significant. I could be wrong, but I think it is fair to say that in the Northern District of California, that is a rather significant development in the life cycle of a petition before the board. So there is a dominant, even if not exclusive, view among many of my colleagues that when Congress saw fit to tweak the Patent Act back in 2012 and among other things create this parallel proceeding or enhance the parallel proceedings that were in place before, it was sending us a rather direct message, right? There wasn't much subtle about it. Patent validity was primarily to be an issue for the board and for experts in the field. And it was, I think, hard for some of us anyway not to take that message a little personally. Many of us fancy ourselves experts in our own right in one form or fashion. But we heard the message, and I think we heard it loud and clear in at least this district. So with a proceeding initiated, I think it is fair to say the statistics bear this out, right? The likelihood of a motion for stay being granted goes substantially up. I do think, however, it is important in pursuing a stay order from a district court, whether it's ours or any other, that all of the ramifications and implications of a stay be considered and vetted with the court as part of that initial ask. We're going to talk a lot about what all those implications and ramifications are, but for many of us, we are thinking not of just the motion before us, but what this whole case looks like 6 months, 12 months, 18 months down the road. So those are some of the things I'm thinking about.
And with an instituted IPR, it just seems, from my perspective, that things are going to change or streamline one way or the other. So that might be a simpler decision. But what about when there's not complete overlap with the claims?
Well, that's the situation that gives, I think, me the most pause. Here's the problem, right? So I think you're absolutely correct, Leah, that the initiation itself is a change in the history and life of the patent, which is material to many of the issues the court will have to confront. So even if nothing else happens, if for whatever reason the PTAB went into a deep freeze forever, its statutory mandate notwithstanding, there would be change that we would have to consider. But in the absence of overlap, I think what I am most concerned about is the prospect that even after 12 or 18 months, even if things go completely south for the patentee on the claims that are the subject of the petition, there's still a case in district court. And all of the things that we think about when considering stays in all kinds of cases, not just patent cases, apply. Witnesses' memories go a little foggy. Judges' memories and understandings of issues get a little foggy. Documents tend to disappear. It seems that in my court that happens more often than most. So delay is always a problem. Delay is something we always worry about. And when there is imperfect overlap, it seems to me that you can almost guarantee that one or more of those ancillary effects will come into being or come into play. And that does give me a lot of pause.
Clem, I wonder if you can talk with us a little bit about that stage in the case, or in the stay, the petition, where the stay has not yet been instituted, the petition has not yet been instituted. Is that different, and how does your practice vary? Do you not file motions to stay?
So I think it is different, and I think there are times when filing a motion to stay a prior institution is appropriate. Just statistically, we know that at least over the first 2 years of the AIA proceedings, 82% of IPRs have been initiated. If we just talk about on a petition-by-petition basis rather than on a claim-by-claim basis. If you go claim-by-claim, it's a little lower. And you have, I think it's 79% of covered business method review petitions granted. Those numbers have fallen off sort of over the last quarter. If you look at them, they're down now in the low 70s, sort of over the last 3 months as the number of petitions has ramped up. But even so, we just know that just from a purely statistical standpoint, a lot of these things are going to be granted. What you often see, I think, in people moving to stay prior to institution is the argument, hey, Your Honor, this is extremely likely to be granted. Just look at all of the statistics, the ones I just quoted. And so what are we doing monkeying around for 6 months when this thing is going to be granted? It's early in the case. Why don't we just put everything on pause for 6 months and let's see how these come out, knowing that on a statistical basis they're likely to be granted. I personally find that form of the motion relatively unconvincing. Because the alternative is really just to say, well, why don't we just wait 6 months and see? And so what I would suggest is if you're moving for a stay prior to institution, that there ought to be something more than simply, hey, why are we going to spend all this effort over the next 6 months? What form might that take? It might take the form, for example, of a particularized showing that the prior art you're using in the IPR is especially strong or especially good, and then saying to the plaintiff or the opposing party, look, point out something here that's really missing from the prior art. Like, give the court some reason to believe that this thing really won't likely be instituted. Make some affirmative showing about it. Alternatively, if there's something that's going to happen in discovery over the next 6 months that's going to be especially burdensome, some particular reason other than simply the normal cost and expense of a commercial case, that's the kind of thing that I might bring forward or petition. But I find the idea that, hey, listen, the normal cost of discovery is very high, and these things are sort of statistically likely to be granted. I think, again, just in terms of balancing the merits, I think that ought to be relatively unpersuasive relative to both the plaintiff's need to move the case forward and their desire to get to trial in terms of where you set things. So I sort of am in favor of the motion if there is something that distinguishes it from simply saying, statistically on average, we have a 70% likelihood of having something instituted, and therefore you are going to, consider the state from now. And so the answer is, I think, yes, it is my practice to bring them, but only in those situations where I have a particularized need that distinguishes it from simply a generic case.
So, Clem, how does it affect your decision when in the litigation process you file a petition for IPR or CBMR?
So here's the thing about that I think is very interesting. From mostly what I do is defense side work, but not exclusively. And the hard thing is really, especially when you have serious patents, it can take some time, and the expenditure of a very substantial amount of resources to really find the best piece of prior art. Given the page limits in the IPR, given the patent office reluctance to consider multiple alternative arguments, they really want you to put forward your best grounds and just proceed on them. I'm very reluctant to bring IPRs on multiple sets of prior art references, and try to sort of convince the PTO through sort of iterative argument, right? You really want to come up with your best reference and sort of put that best foot forward. That can take some time to bring it forward. And so I tend, I think, just in my practice, not to move for IPRs really super early in the case. Because I generally don't know quite enough about what I think about the prior art and what I really think about the technology until I've had some time to really mull it over and think about it. That can make it more challenging to then move for IPR and then come to the court and say, look, we really need an IPR prior to institution because, wait a second, Mr. Roberts, if you really wanted to save everybody some money, why didn't you just file this thing earlier, right? You took your sweet time to get to this point, so therefore why should I be in a hurry to grant your stay? But that's just from a strategic perspective, that's a trade-off I'm willing to make because given the sort of one-and-done nature of the way in which the IPR is considered, I think it's more important for the petitioner to really make sure you're on top of your best heart.
So can I ask one other question? So, and Clem and I have dealt with this in real time. We've been batting each other over the head on these motions for a couple of big companies. But assume for a minute that you have a competitor case.
Yep.
And you're going to file a petition for IPR. If it's a competitor case, does that affect your decision on whether and when to seek a stay?
So I think the answer to that question is no, because I think with a competitor case, obviously the competitor's ability to show irreparable harm or the likelihood that they're going to be able to show irreparable harm as a result of the delay is higher. But I don't think that let me put it this way. If I file an IPR and we've got a statutory 18-month period between the time that I file and decision, I don't think that their irreparable harm goes up if the window slides over, right? If I file it in month 1 of the litigation, or if I file it in month 6 of the litigation, the amount by which their ability to get relief or to seek an injunction against me is being delayed, but it's being delayed by the same net amount because of the statutory timeframe and the fact that these petitions take 18 months, almost like clockwork. Like that's how much time it's going to take. So I don't think it impacts when I file the stay, although I do think, Ian, that it should make a difference to the court as to whether the court is likely to grant the stay in terms of how it weighs the benefits of the stay against the costs.
Do you have any counterpoint to that, or does that fit what you're thinking?
I think one of the one question I have, and I'll tell you if you email me on April 28th. This one isn't against Clem for a change, but it's a competitor case, and the motion for stay was made many months ago, and the judge just is addressing it now. But it's an interesting case because the judge set a 3-year case calendar. The IPRs will be over and done 5 months before trial. In fact, before summary judgment motion is briefing's finished. So it's an interesting question how the case calendar and the IPR calendar overlap. And so you have judges with a very fast calendar saying, no, I can get the case done before the PTAB can, so I'm not going to stay. But what about in the circumstance where you already have a very long schedule, 3 years I think is reasonably long, and the IPRs are compressed sufficiently, or they were filed sufficiently early, that they're going to be over and done with before the judge really has to spend much time on the case.
And if I could go back to Judge Grewal for a second, because when we first started, you were saying that one of the things in terms of granting these motions you're really looking at, or that really troubles you, is when not all the claims are instituted. So you know that at the end of the day, you're going to have to rule on them. To what extent are you finding that the statements that people are making during the course of the IPR, prosecution history, estoppel statements, statements about the prior art, are helping you to understand the patent and the technology and what's really at stake, and how do you weigh that off against the fact of delay that you had been concerned about?
So conceptually, I get it. It's entirely speculative, but nevertheless imaginable that statements will be made that will shed substantial light on the meaning of the claim terms. My fundamental, it's Friday afternoon, so why don't I tell you what I really think?
This is perfect timing for Judge Grewal.
It's been a long week. My fundamental problem with stays generally, but particularly in this context, is something Ian alluded to, which is, in so many ways, and I'll put myself at the very top of the list, it is an easy out for the lazy and the disinterested. Because the fact of the matter is, if Congress has made it clear that it wants these validity questions resolved quickly and efficiently, why aren't the courts solving that problem, right? Why are we setting 3-year schedules to get to trial? Why are we sitting on Markman submissions for months on end? There's no intellectual justification for it. We point to the crowded dockets that we all struggle under, and we point to the complexity of the issues and the challenges of any patent. Well,
Endless discovery.
Maybe we need to up our game, right? Maybe we need to look long and hard at ourselves and ask, what got us here to a point where the Congress decided we weren't good enough to solve these problems, that we needed to turn to the administrative agency to provide a more efficient, more expert solution to the problem. And I think that in so many cases when stay motions are presented, and again, I'll put myself at the top of the list, there is a massive temptation to say, sure, why not? I have 507 other cases on my docket as of 9 o'clock this morning. I'll happily turn to those. And so, I do think that these conceptual issues are important to think through, and I can appreciate that there may be some benefit, substantial benefit, from that additional prosecution history. My concern is that we're just not being very honest about what's really motivating the judge to grant the stay in so many of these cases.
And one final question before we move on. Eliot, is there some point in the case where you just can't file a motion to stay? I mean, does the timing ever work out where you're just not going to do it?
I mean, I filed motion to stays after the mandate issued from the Federal Circuit, so no, I think the answer to that is no. But in terms of whether you're likely to get it, yeah, I mean, obviously, the closer you're getting to trial, the more inertia is building up in the case. I think the judge is far less likely to grant the stay. But it's always. I mean, I'm sure Judge Grewal would agree. Every stay motion, I think, is fact dependent. I mean, as much as we think it's the same issue every time, the facts are always slightly different. Something has occurred in one case and not the other that might change the calculus.
All right. Well, this morning, there were some interesting discussions about other entities who are not involved in the litigation filing these petitions for IPRs, and a representative of EFF is here and talked about her charitable organization and some of the work that they do. I believe there's a case that recently got to the front of the news with Unified Patents filing the IPRs. So if we tie this back to motion practice, can an entity that's not a defendant, essentially, that's not a party to the IPR, Ian, I mean, what do you think there? Can they file a motion to stay?
What do you mean, can they? They do.
Tell me all about it.
So not only can they do, and it's often granted, right? So the court will go, so I think of it as sort of two basic situations that arise. One is that there's litigation against multiple defendants in different venues, and a defendant in one venue moves to files a petition. Other defendants often say, okay, why would I file a petition on the same art? Because if I don't file a petition, I don't have the estoppel problems. And if you look at the standard for a stay, one of them isn't whether you are a petitioner, right? There's either for covered business method patent review or IPR, you don't ask the question, is the party, the defendant moving for a stay, also a petitioner? So the question is, what does the court do? And the courts have done, what a surprise, pretty much everything. So in a number of cases we've had, judges have granted stays against, in favor of defendants who are not parties to the IPR, not even arguably real parties in interest, because they think it's more efficient. It's certainly more efficient for their calendar because they don't have to deal with it, but they think it's more efficient. We've seen judges deny stays even where the defendant is the petitioner because, as Judge Grewal alluded to, the court says, I'm an Article III judge. My job is to get this case decided, and I'm going to decide it on my schedule, and I'm not going to defer to an administrative agency. My job is to decide cases, and we've seen that. And then we've seen in the Northern District, although I've not actually been a representative party in one, but I've argued the Northern District standard, which is what I call Estoppel light. So in covered business method patents, the estoppel already is estoppel light. You're only estopped as to arguments you raised, not those you could have raised because you've got a lot more choices. But in IPR, of course, a petitioner is estopped from asserting any art. Remember, it's only 102 or 103 art, but any art that was raised or could have been raised. So the question is, if you have a defendant who is not the IPR petitioner, what, if any, estoppel should be granted? And remember, the court can only condition the stay on the defendant agreeing to the estoppel. The statute doesn't impose estoppel on a non-petitioner. So there have been three flavors of this. In a number of occasions, we've seen no estoppel at all. The judge's reasoning is they can't control the IPR, why should they be estopped? We've seen a couple courts have said, you want to stay, you are fully estopped, notably Texas. So even though you're not a party, if you want the benefit of a stay, you have to accept full IPR estoppel. And then you have Northern District, which does what I call estoppel light, which is you don't control the IPR, so you're only estopped as to art that was actually raised, not art that could have been raised but wasn't. which seems to me a fairly reasonable middle ground. I think if you're a defendant who wants to take advantage of somebody else's IPR petition to stay your case, it's not unreasonable to say that you should have some estoppel effect.
So let me ask you a question about that. Because it seems to me that if I represent defendant A and someone else represents defendant B.
Same case?
Same case, same patent, let's say, and defendant B files an IPR on a particular patent. And I'm litigating in front of the judge, and I ask the judge for a stay. And the judge says, okay, I'm thinking about imposing estoppel light, as you put it. Only one of two things is really going to happen, right? In the petition, in the case where the IPR has been granted and is moving forward, the IPR is going to be granted, patent's going to be invalid, estoppel light doesn't apply. So we're really only talking about the situation where the person who filed the petition either settles out, so there's no actual decision on the merits, in which case it doesn't seem to me equitable that estoppel light ought to apply, or where the PTO issues the patent over and above the estoppel. Where it's issuing it over and above the estoppel, there's two ways it could issue, right? It could either issue unchanged with no changes, or, especially now post-rules, you could have the claims be amended. And so the only situation where, of all of those branches, where it seems to me estoppel light really might make sense is the situation where the claims issue unchanged over the prior art. Because if the claims are being amended, that's really something where, now the whole condition of the case has changed, what the prior art is that's going to be relevant has changed, the infringement reads are going to change. There's a lot of change that's going on there. And simultaneously, in the branch of this where, it's settled out and there's no final decision on the merits in the IPR, estoppel would apply, and that doesn't seem to me to be equitable. Do you see it differently?
No, I actually, the last point I agree. It doesn't seem right that, because we have no idea what the deal is, right? And so we know that the petitioner got some benefit, or he wouldn't have settled, the entity got some benefit, and the non-party presumably didn't get that benefit. So it doesn't seem equitable. I agree with you. Most of these estoppel-like cases, well, all the estoppel-like cases arose before it was really practicable to have an amendment.
Yep.
So we really haven't seen that issue. Really what we've been dealing with is a situation where either the patent dies in IPR, in which case it doesn't matter, or the patent comes out of IPR pretty much the way it went in. And then estoppel-like, it seems to me, does matter. It seems to me at least a reasonable approach.
So I'll confess, I'm not sure I've ever issued a stay order with an estoppel light provision included. I have issued what I suppose under this taxonomy we properly labeled as a estoppel zero or diet estoppel, where I would have the defendant who is not a party to the petition sign on to whatever estoppel would otherwise apply as if they were a real party in interest. And the reason for that is where I have done that is where I've had this sneaking suspicion, no actual evidence, mind you, but more of a spidey sense or something, that the collusion, small c, not big C, the collusion among parties is not entirely reflected in the record before me. And so it just seems to me to align incentives, not perfectly, but at least align them in some fashion to put to the party asking for the stay some cost, some price they must pay in order to get the relief that they're seeking. And I will confess, I think that it is an imperfectly measured cost or price in most cases, but I think it's important that it not just simply be, give me my cookie and I'm going to go home.
So let me ask a question about that. So I totally understand that. The issue I have with it conceptually is I cannot imagine as a party representing that if somebody goes through and they go all the way through the PTO and they go on a combination and the PTO says, sorry, even under the broadest reasonable construction, claim no amendment, this thing issues, that I'm going to go to the court and say, Your Honor, this is the piece of prior art on which I want summary judgment. I mean, if you had any other option, you wouldn't do that. The problem with all of these, like estoppel light or estoppels, is that there's there's actually a lot of permutations to it, which is what I was trying to point out in my earlier question. I mean, one of them, for example, is what if, and directed to Judge Grewal, what if the defendant wants to use one, it's a combination IPR, and the defendant wants to use one base reference with something else? Would you say, sorry, that one reference, I'm conditioning your ability to get a stay. You can't use that reference, even if you want to use it as part of a very different combination. Let's say that the reference is being used to fill in one limitation for a dependent claim, and they want to use that to hit the dependent claim in combination with some other base reference. You can't use that reference. So I totally understand the instinct, but what I wish there were a way to do is to not to condition the stay on the estoppel, but to say to the litigant sort of very seriously, look, if you want the stay, I'm telling you right now, I'm not going to consider the identical arguments that the PTO considered. I mean, I'm not going to formally stop you from doing it, but I'm telling you, you have a very uphill argument with me.
What if instead of conditioning it on an estoppel, I conditioned it on a bond? Right, something, anything. In so many other cases, we put to the party something that says, okay, if this doesn't work out as swimmingly as you hope it to, there will be some price to pay, because there is a time value cost to all of this. But I agree with you. Trying to figure out all those different permutations is important. I also want to suggest that vetting these issues, talking through these issues with the court at the earliest possible moment is key. Right, I will never hold it against anybody who at the initial case management conference walks in and says, we haven't filed a petition yet, we're exploring the prior art that's available, we were only served with a complaint in this case a week or a month ago, but you should know, Judge, we are looking at that, and if and when we find art, and if and when we file a petition, and if and when that petition is granted and proceedings are initiated, we anticipate coming back to the court, and here's how we see that playing out. If you take advantage of that opportunity, I think you will be miles ahead of most parties. And the reality, right, is, I mean, you know, we all litigate for a living here. It's not like a heck of a lot of other things are going on at most case management conferences, right? They're usually this completely perfunctory exercise where people come in, they smile at me, and then they go on their way with a scheduling order. I think that is a valuable opportunity to raise some of these issues that more people ought to take advantage of.
But Judge Grewal, in your experience, don't people really flag everything they can see? I mean, when we go into a scheduling conference, we try to flag every issue we're aware of. We're likely to file a motion on this. We haven't decided, but we're likely to file a motion. We're likely to file a 101 motion, amazingly, although in the cases against Clement, I represent plaintiffs, I represent defendants pretty much as often. And so if we're going to make a 101 motion, I tell the judge early so that he understands it's coming down the pike. Don't people just sort of tell you what they think is going to happen?
No. I mean, so I have this section in my standard scheduling order, like most judges, that says what motions are anticipated, right? 98.6% of the time it's defendants anticipate bringing a motion to dismiss under Twombly and Iqbal, or defendants anticipate bringing a motion for summary judgment on invalidity or non-infringement. Well, that's not terribly helpful and useful. So no, it is much more the exception than the rule that I get that kind of granularity, but I think it's important.
So I was actually going to propose a potential alternative to Estoppel Light for consideration, just see what you guys thought of it, which is I, as the district court, will not hear a summary judgment motion based on the art that was brought in front of the PTO. So if someone else is bringing an argument in front of the PTO and it's resolved adversely to them, if you really want to make that the core of your jury argument, go ahead. But I'm not going to let you out. You can't bring summary judgment. I'm not going to hear it. That's fully within the discretion of the district court. It allows you the flexibility downstream to sort of account for some of these varying possible outcomes with it and to change your mind. So it's, and to sort of shape it a little bit. But just to say, you know what, you can't move on that. You get one written pleading in front of the PTO. They'd say no dice. I'm not going to do that as a matter of law.
Clem, does the plaintiff then get to say, this extremely experienced body, the PTAB, looked at this prior art and said, nah. So are you going to let the jury hear that what the PTAB did? Because my sense is most of us think that at that point, you might as well not bring the art before the jury.
So, yes, I do think. I think that that's the other piece of it, which is if you're going to move on art in front of the jury, I think a fair balancing of 408 is to allow that in. But as we've talked about in prep for today, I also believe that PTAB proceedings should come into the district court far more often than they do, both on the plaintiff side and on the defense side. So I'm not actually adverse to that, yeah.
Yes.
Can I ask whether people's views differ on the propriety of stays depending on whether this is a competitor case or a toll case? Right, because so Judge Grewal suggested, well, hey, well, maybe there should be a bond, right? Because you've hurt the patentee if you grant a stay and then and the case is all put back by a year. Seems to me you've hurt the competitor quite a bit more than you would have hurt a non-practicing entity whose damages are running up. It's not zero that you've injured them. And then the other question, I guess, is could you imagine the bonds being reciprocal? So you can imagine a kind of loser pays rule for stays. If I deny a stay, and then it turns out a year later the patent's invalidated and you wasted a year's worth of litigation costs, well, maybe the party who opposed the stay should pay that cost.
So this is why, actually, as much fun as I have trying patent cases, I have even more fun settling them. Because in the context of settlement conferences, we can come up with all sorts of creative escrow accounts and other mechanisms for addressing that risk. To answer your question, Mark, I do think that the competitive posture of the parties matters. It matters a great deal. Although I will confess, as I've thought about this in one or two cases, I've often wondered exactly why. Because I think pre-eBay, right, when injunctions, I'm told, back when the dinosaurs roamed the earth, were a matter of course, the reality now is that there's very little injunctive relief, exceedingly little injunctive relief in almost every patent case, right? It's statistically a rounding error. And so looking at the harm to the competitors in terms of the absence of some type of equitable remedy, I think is appropriate, but I do think there are harms that come beyond just the lost time to get that injunction, and I don't think that the prejudgment interest can capture all of that in every case.
So let me give you an example. I agree that it matters. I don't know how much it matters, and I think some of it also is a question how long the time to trial is, and when in the litigation calendar the IPR is filed. Right? If you file the IPRs near the end of the case, you have a 3-year case and you have a year and a half of stay, and then the question, of course, is what about federal circuit appeal, right? Does stay continue? I mean, there's all kinds of these issues. But imagine a scenario where you have a small but practicing entity, competitor, who is being killed in the marketplace by a larger company. If you push the day of finality out more, it's not just may not be compensable by interest, the company may not be around to receive compensation at all. Not as likely with a non-practicing entity, although not impossible, right? I mean, a lot of the non-practicing entities don't have unlimited funds either, and so delaying their ability to recover also has effects. They don't have operating effects. They're not losing money manufacturing products and selling at a loss, but they have consequences too.
And the small competitor case, I think, is very interesting because actually, if the small competitor goes out of business, it actually helps the large competitor, not just but just from a lost profit standpoint, right? Now, I think there's a good argument that the small competitor is no longer entitled to lost profits because it doesn't have the capacity to make the devices anymore. So if you can force them to shut down and become an NPE by delaying the day of judgment, I do think that there is a real concern there that the small entity is losing not merely time and market share and those kinds of things, but it's actually also going to lose a really good argument for damages, and its measure of damages is going to go down to a reasonable royalty. So I do think that's also a concern.
Well, there's been a little bit of discussion today, a little bit about the real party and interest and the restrictive view of discovery right now at PTAB. And I'm wondering, Eliot or anybody else on the panel, does this have an impact? Does it matter? And there have been some comments about potentially expanding discovery. Eliot?
Yeah, no, it definitely matters, and it actually goes back to something Judge Grewal said, which is his spidey senses go up when he sees a petition go in by maybe one defendant and not the other. And I can say from the defense side, when we're in a joint defense group with other defendants, I am terrified about discussing IPR strategies with other defendants. because of the real party and interest issue. Even if I mean, for the one, if my client is considering an IPR and I file it and it turns out we've improperly coordinated with the members of the joint defense group and that comes out in discovery somehow, whether the district court or the PTAB, that can kill and has killed several petitions just on a procedural ground. So it is, I think, the real party and interest provision does have teeth, and I think, so that should give you some comfort, Judge Grewal, as the Patent Office is, I think, doing a good job policing it. But it's fair to point out that there's not much in the way of discovery that's permitted, but there is some. I'm facing an IPR right now where we're in a heated battle over who the real party and interests are, and the other side has moved for discovery, and we'll be opposing that motion. And the board has made clear that some discovery will be permitted, but as with all PTAB discovery, it has to be narrowly focused, and you sort of have to know that there's some useful discoverable information out there when you bring the motion. But I think the PTAB is doing its job. I mean, Congress has said the PTAB has to police this real party and interest issue, just for the exact reasons we talk about, to make sure that the Estoppel provisions are enforced properly. And so, I do think it's a real provision, and they're doing a good job with it.
Go ahead.
Oh, I was going to say, the concern I have is, I've also been very careful, but the problem I have is I think the potential for abuse is enormous. Because even if you do grant the discovery, I don't see how you get it. I mean, the common interest privilege is extremely strong. Unless counsel are including in the subject line of their emails and on the privilege log, you have to, hey, what about that re-exam? Shouldn't we use this piece of prior art? Unless
I have seen logs that say that.
Right, I mean, unless people are being extremely careless, the potential for malfeasance is very high, right? So the sanctions are very high, but the likelihood of getting caught is extremely low. And I think that is I think reputable counsel isn't going to come close to that line and is going to be careful. But I think the potential for abuse and the potential for concerns are really high. I would like to see a system that shifted towards a slightly more liberal standard for discovery and allowed a greater range of it, but then had a less draconian sanction. Right? So if you were found to technically be a real party in interest or to have communicated about IPR strategy, the full scope of Estoppel attaches, for example, right? Or you could be required to pay some percentage of the reexamination proceedings, right? There are sanctions that could be levied rather than, hey, look, we're no longer going to decide this proceeding on the merits. Other than a merits termination, that I think would be effective deterrence if they were imposed more frequently. And then I think you would have greater discovery, you'd have a great, it wouldn't be the death penalty, it would be, a severe beating.
So that suggests, right, that the right remedy is actually in the district court, not in the PTAB.
Yes.
So people understand that that if you manage to get the real party and interest wrong, the remedy, according to the PTAB, is dismissal. Right? You don't get to fix it.
Yeah. Well, so actually, you could refile if you still have time,
Yes, but you
but
can't
you
fix it.
usually won't have time.
But you can't fix it. You can refile.
Yeah, you can
if you're
refile
within the year.
if you're within the bar.
And it matters because it could be that the petitioner filed within a year, but by the time the real party and interest decision has been made, it's more than a year and too late. Or the party who turns out to be the real party and interest has the clock has already run on them, which has happened. And you've got to also be careful. So there are obvious real party and interest cases, and then there's the RPX case, which is interesting, where RPX, on its own behalf, filed an IPR, and Apple was held to be a real party in interest. It had contributed some money, and that's about what it did, as near as I can tell, although it talked about strategy, but didn't otherwise control the IPR as far as the record shows. And the PTAB said you didn't disclose the real party in interest, and Apple, if I recall right, was time barred. So goodbye IPR. So you got to be, and there's a second case that came out, I can't remember what it is, but held the other way. So some other association.
I think they're here today,
Unified
actually.
patents, I think.
Pardon?
Was it Unified Patents?
Yes.
Yeah, okay.
But they were being very, very careful, and so they didn't have the
So
problem.
let me ask this to the other panelists. What discovery, other than the invasion of common interest privilege work product, could be granted that would, in most cases, allow the uncoverance of this, right? What is it, Judge Grewal, you would say, hey, this is something I would consider granting if I were asked for this discovery because it has some chance of succeeding. It's not merely an attempt to invade the common interest, joint defense agreement.
Well, I can imagine that if the record were made, even if the common interest privilege apply, there's always the crime fraud exception, right? But that's a pretty high bar.
very high bar, right?
I grant you that. And as a practical matter, right, I think you are absolutely correct, Clem. Under what circumstance would these communications be held or be made other than under the guise of a joint defense group, common interest privilege, all that good stuff? So yeah, it's pretty hard for me to figure what that discovery would look like. It's also hard for me to figure how exactly I'm supposed to think about this if I have declined to stay the case and there's a case proceeding in front of me, or as well as a proceeding before the PTAB. It's been known to happen that a party will seek discovery in district court that isn't really for purposes of the district court litigation. And I have a really, really hard time trying to figure out whether that's the case and also what I'm supposed to do about it, right? Should that matter to me? Because I think we do not have the narrow standards for discovery, unfortunately, in the federal rules, right? We have a very broad standard. So it's pretty easy to make the argument that the same information that you'd like to have for the PTAB is discoverable in district court under some form or fashion. And I think in most cases, it's almost impossible for the judge to know the real purpose of securing or seeking that discovery.
So I can see two ways to go. If you're going to, three ways. You can simply not allow discovery, right? And argue there's a
Sign me up. I'm up for
joint
that.
defense.
Yeah.
On anything. I know you're wrong. No discovery. We'll do it the European style. No, you could do three things. You could just say that it is what it is, and you can't get discovery. You could do something like you have to identify when possible IPR was discussed, not what was discussed about it, but when it was discussed and who was part of the discussion, timing-wise. You could do that. You could also shift the burden. You could say, if you're part of a joint defense group or something else, and you contend you should not be stopped because you're not a real party in interest, prove it. Now, that one's problematic.
What would you accept as proof?
Well, the problem is you probably have to waive privilege.
Yeah, see, that's right.
And
This
so
is
I
exactly the
like
problem.
my middle ground, which is you get a little bit, and maybe if the judge thinks there's enough that he wants to further invade privilege, knowing what that means, the judge could say, okay, where there's smoke, there's got to be fire.
So I think there's a mechanism for that under the current rules, right? So absent an agreement of counsel or the parties, those communications ought to be logged, right, if they're otherwise responsive to an outstanding request. The reality, of course, is everybody wants to avoid the morass of dealing with post-filing communications, so they all just sort of agree to not deal with it and waive that. But I can imagine, again, thinking carefully about this up front, counsel carving out an exception for those communications to allow a court and opposing counsel to explore that issue. I think something like that makes a lot of sense.
Any questions? Well, in the prior discussion or earlier today, the Kamal case came up, which is a Cisco case that was just argued at the Supreme Court, and it was the issue of whether the lower court should have allowed evidence of a good faith belief of invalidity. And as we were preparing for the session today, we wondered, should an IPR be evidence of the basis for a good faith belief in invalidity? And of course, that assumes a certain result in the Kamal matter, but it gets into the issue of the admissibility of these proceedings in the district court. And I wonder, Eliot, have you had any thoughts on this issue?
Yeah, well, and it would come up in willfulness too.
Yeah,
No matter
exactly.
how Como gets resolved, I think there would still be the potential issue of willfulness. So yeah, it's an interesting question. It strikes me that the final written decision should be treated like any other part of the prosecution history. I don't see why you wouldn't look at it that way. Obviously there is the potential for prejudice because the jury might misunderstand what exactly was happening in the PTAB if they're told about the final written decision, and so care would need to be made to explain the limits of that result. But I don't see how the final written decision is not sort of equivalent in many ways to the rest of the file history. But before that, the institution decision, I think that's the trickier question. And I think probably it is the case that it is simply too confusing to explain to the jury sort of what the institution decision means, comparing it to what's going to happen in the rest of the proceeding, and giving the appropriate cautioning instructions. I think that would be extremely difficult. I don't know if you've dealt with that.
Well, it's pretty interesting, right, how selectively we trot out juror prejudice or confusion in patent cases, right? So God forbid we would explain to them that there's this other part of the federal government that does one thing, and we're all here to do another. And at the same time, we throw at them these brutal patents involving DRAM architecture and tell them to go figure it out for themselves. So I actually have a little more confidence in the jury on this question than I do on a lot of others that I subject them to. But I do think historically, Eliot, you're absolutely correct that there has been a resistance on the part of the court to open up the box of what happens at the PTO in front of the jury in any way, shape, or form. In large part because you really do run the risk of having a satellite proceeding within a trial that may already be subject to time constraints and other limitations that are imposing upon the jurors.
So my problem with this is, I look at this and I say, okay, so let's assume that it's actually the defendant who sought IPR. It's a real interesting question if it's not the defendant, right? It's somebody else. But it's, so the defendant files for an IPR. Let's suppose there's a non-institution decision. Does that mean they don't have a good faith belief in invalidity? I mean, so, you look at this and Judge Grewal said how confused the jury is. So I'm going to tell the jury that the patent, show them the movie, right? Any of you are litigators, you've seen the patent video, and it tells you how the jurors, how a patent gets issued. And then you say, and by the way, what the good patent office giveth, the good patent office can taketh away, right? So then you have to explain what, PTAB proceedings, IPR proceedings, covered business method patents, and then you have to explain, well, what an institution decision means, or the failure to institute means. I mean, my concern is, I'm not sure I wouldn't allow it, but if I were a party, I would be really nervous on this.
So here's the way I think about it a little bit. I have a slightly different perspective on it. There's a lot of buckets here. One is that it's been filed, but there's been no institution decision at all. For me, I don't see how that's really different from an advice of counsel letter. There's a letter that's out there. It's been public. You have interesting questions about whether you have a waiver of the communications that go into the creation of the PTAB, but that is, I think, something that can be dealt with. But that's a letter. It's a set of legal arguments. A person in the company can look at it and have a belief about it. It's a basis for a good faith belief. I don't see why it would be any different from a letter. In an institution decision, Ian asked the question, well, what if it's rejected, right? And I would say, well, you can rely on it for a good faith belief for a period of time up to it being rejected. If it's been rejected by the PTAB, I think it'd be a tough sell to say, hey, the PTAB told me that this thing was wrong and it didn't get instituted, but I continued after the date of non-institution to have a good faith belief based on the letter because I had a good faith belief that the PTAB was wrong. That strikes me as a very weak argument. If the PTAB does institute it, then at that point it's pending. And I think you have to let it in. There is a Federal Circuit decision, although the name escapes me at the moment, talking about this in the case of willfulness and said that it was error to exclude it, that it did have to come in. And so the problem that is being pointed out is, well, wait a second, doesn't this create a real problem with explaining it? And if I had the black robes, what I would do is I would say, listen, plaintiff, you have a choice. The choice is you can go forward, you can make your indirect infringement argument, and I'm going to let this in. Or we can stay the case and you can let it resolve. Because once it resolves, once you have a final decision on the merits, I don't think it's a problem. If the final decision on the merits invalidates the patent, fine, it's gone. You don't need to introduce it for anything. If it issues with no changes, well, then, I mean, you could, you if the defendant, if you wanted to introduce it as a argument for yourself to say, look, I had a good faith belief up until the time that the PTAB told me I was wrong, I mean, go ahead and introduce it. Then the plaintiff is going to stand up there and say, Your Honor, they've opened the door. I get to sit there and bang on this drum as loudly as I want to. Or you have the situation where some of the claims have been invalidated and some of the claims have not been invalidated. You know, for the ones that have been invalidated, they're not in the case. And for the ones that haven't been invalidated, again, I don't think you as the defendant are going to want to bang on that drum. So I think it resolves at the end. The question is really the middle, and I think you can resolve the middle by giving the plaintiff the choice of going forward and having it come in, or waiting until it gets to a situation where it's resolved.
So I'm not sure it's a whole lot worse than the situation with advice of counsel, because anybody who's been through a patent trial knows that an advice of counsel letter is only relevant if it's wrong, right? If the letter's right, then there's no infringement or the patent's invalid. It only matters if the letter is wrong, that you've found to have infringed a valid patent. So you're sort of in the same position. You're saying, well, this letter gives me a reasonable belief, even though it's wrong. So I don't think that it's anything worse if you come out of the PTAB with the PTAB says its institution decision is grant institution, and then it upholds the patent. Maybe that's even a better case for the state of mind.
Well, my only suggestion is that there is another alternative, which I alluded to earlier, which is to explain to the jury as best you can what's going on. We do this all the time, and I suspect if we go down that road, in certain cases, we may bring back my favorite expert of all time from the early days of patent litigation, at least in my career, which was the patent office procedure expert. Remember those folks?
Oh, yeah.
That was classic. We'd have these people come in and talk about what's going on in patent law for 3 or 4 hours. I do think that an instruction can work. It may not be perfect, it may not be ideal, but it can get us most of the way there. And I do think that particularly in a time-limited trial, which is most patent cases most of the time, you put these choices to counsel and they live with those choices.
Well, before we run out of time, we wanted to address the Fresenius issue and whether or not we're in a race now to get to a final affirmance.
The answer is yes. I mean, and so this is the problem when district courts don't stay their litigation when there's a parallel PTAB proceeding happening. It is in some sense, I think, against the sense of Congress when they pass the AAA for that to happen, but it certainly can happen. It's happening right now in a case my firm's involved in that I've been asked sort of to give some advice to, where we had a jury trial go all the way through and find infringement and no invalidity of the patents, and a month later the PTAB invalidated all of the patents. It's a totally separate proceeding. So now what do we do? So there's a lot of interesting things going on now. So the Estoppel provision of the AIA actually says that once you have the final written decision, the invalidity issues go away. So now the accused defendant is really probably not able to even appeal the invalidity issues from the district court anymore because they've been sort of rolled up into the PTAB proceeding and they've now been stopped. So the other thing that obviously is going on is the patent owner is appealing from the final written decision in the patent office. So they're getting the benefit of that Estoppel statute to some extent because now the accused infringer can no longer make invalidity arguments in the district court, but at the same time, the appeal is going to go forward. I mean, we're going to have to enter final judgment in the district court and whatnot and proceed up to the federal circuit. So both things are happening at the same time. I think in this particular case, both appeals are going to be in the federal circuit at the same time. So, and for those of you who don't know the Fresenius rule, basically the race is, who's going to win this battle because you can't get a final judgment entered and a mandate spread on a patent that's been canceled or on claims that have been canceled. So now we're in a race to see whether the defendant can get the claims canceled before the plaintiff can get their infringement verdict sent up and a mandate spread from the federal circuit. So, we'll see what happens. The federal circuit's obviously going to take the brunt of this and trying to sort out how to run this line, but you may have cases where they're not going to be in the federal circuit at the same time, and whoever wins this race is ultimately going to win. And obviously, it seems like a big waste of resources either in the district court or in the PTAB, but that's sort of how things can shake out if stays aren't entered.
Although that case, in fairness, that case went on forever, right? I mean, that was, 7 or 8 years?
Fresenius?
Yeah.
Yeah. I mean, those facts are a little
So the facts, I mean, if you look at the facts of that particular case, you might come to the opposite conclusion, right? Which is at some point, they should have had their final judgment long before the PTAB dealt with it.
Yeah, no, I mean, that's true, and it was an unusual case, but I mean, I'm describing right now something that happened, a few months ago that's going to be a live issue in the federal circuit, and I think can repeat if, when district courts don't stay for whatever reason.
And what's interesting about that is, right, you do have a situation where you can lose in the district court and then win in the PTAB, and that has one set of implications. I'm also interested in what happens if you win in the district court and then lose in the PTAB. Especially, you know, let's say it's an issue like 101, right? You file a covered business method review, you move for summary, the district court refuses to stay. You move for summary judgment, you win in front of the district court, and then the PTAB goes the other way. All right, at that point, I think you have a real interesting issue too, right? Because you can't, as the defendant, I don't know that you can defend that on appeal, right? I mean, you're stopped, right? So now you have to appeal the PTAB decision and you only have one vehicle to try to appeal it, which is the PTAB decision. And maybe the two of them get combined together at oral argument and you don't have a problem and the timing all works out. But there's a lot of potential timing problems, yeah.
So one question as a strategy matter on that is, when the district court rules for me on the 101, do I immediately go withdraw my CPM? And hope that it'll be affirmed on appeal by the federal circuit, right? Or do I try, roll the dice for double or nothing and try to get the board, tell the board about the court decision and see if they'll do it?
I don't think it helps you. Because if you withdraw the CBM petition, why don't you end up with a final certificate and a final ruling on the merits in the PTAB, and therefore, why aren't you stopped?
Well, certainly you are stopped if you settle it, but a theory is that I'm dismissing it.
But if I'm the plaintiff at that point, I don't agree to just let you walk away from it.
So you certainly could dismiss it before institution, but after it's
Post-institution, I think you're
I don't
stuck.
know that you can do it. I think you're stuck. You got to win both.
Are we sure that you can dismiss voluntarily before institution? I'm not so sure that that's clear in the rules. I just had to get the other side's permission to do that in one of mine, and we had a long conference with the board about it. So I'm not so sure it's that clear. I think once you've put this thing in play, it's not so easy to get it to stop.
Is this an argument for stronger stay rules?
Yes.
I think mostly this is an argument for doing trusts and estates.
Get out of patent law.
Oh, yes, there was a question. Yes.
There was a case early on where the patent owner won their case in Texas, and then the petitioner filed an IPR, and the patent owner responded in their initial preliminary response saying, we've won in Texas, this case can't be brought before the PTO, before the PTAB. PTAB denied that and said, it's not a final decision, we're going ahead.
Yeah, I think that's the right result, by the way, on the statute. I mean, the PTAB is free to take it up at that point until there's a final judgment that's entered. And if a final judgment is entered and the mandate is spread, then I think the PTAB proceeding has to go away. But if they're able to somehow finish the proceeding and get it up to the federal circuit in time, there's no reason that they can't win the battle.
Yes, there's a question. Professor Duffy.
So one possibility when you appeal from an administrative agency is the court reverses the agency, but simply says that we're reversing because we don't like their reasoning. So that's a sort of standard thing that happens, and the agency is, in theory, free to go back and provide additional reasoning. For example, the federal circuit, let's say in your situation, could reverse the PTAB because maybe it didn't take into account secondary considerations, objective evidence, or something like that. That goes back to the board. And then, I think then the federal circuit has to hear the appeal from the district court if they think, if it's a jury decision or a district judge decision about validity, it may very well affirm that under the relevant deferential appellate standard. And then there's really a race, right? They've got to try to petition for cert and try to get extensions of time because, they are then looking towards a new PTAB decision while the time is really running out. So that's actually one situation where it could be incredibly valuable just to get the board reversed on its reasoning, rather than sort of the federal circuit saying it's patentable, but just saying your reasoning's bad, go back and do it again. It could be a real defeat.
So I'd appreciate if you don't write about that anywhere publicly in the next few months. But no, yeah, we were, so my client, our firm's client was the accused infringer, yeah, so we're the petitioner, yeah. So that doesn't help us too much.
The other side?
And do you have
No
a
comment.
telephone number?
Well, see, and I think the way for the Federal Circuit to try to do this is to try to consolidate these things, right? They have the ability to bring these two proceedings together and hear them together under the same roof. And, you know, the Federal Circuit moves through its docket with relatively expeditiously. But there are times when appeals take a little while, and one would hope that they're out there looking at what else is coming and trying to figure out, right, how to try to avoid some of these conflicts. But that also then gets into the very interesting question of what are they going to, I mean, I haven't seen one of these things where you have a grant of summary judgment in the district court and a denial in the PTAB, and now you're trying to resolve it under two standards at the same time, substantial deference, right, and you know, as a matter of law, and you're trying to do that. And it's especially going to be complicated if the defendant can only argue under one of the two standards and not under the other. So, I mean, this is, again, a reason to prefer very strong, I think, stays so that these things happen sequentially.
Well, it's even worse, I think, because in so many cases you have not just one patent and one claim at issue in each entity, right? You almost always have several claims across several patents, and the odds that you're going to run the table on a summary judgment motion of invalidity, even in the Northern District of California, are relatively slim, right? So how many district judges are going to even proceed to enter that judgment if you get it granted because of the other claims that are outstanding? So it gets even harder.
Would you consider granting a order for interlocutory appeal, certifying to allow an interlocutory appeal in order to avoid such a timing issue if a party brought that issue to your attention?
Oh,
Or would you say
I'd
no?
consider it. Whether Judge Moore or anybody else would actually consider it on her end, I think is probably a more interesting question. My impression is that the circuit is less inclined to do that than maybe some district courts are.
A question came up earlier today. Does TAVA apply to PTAB decisions? I'm curious. I don't know.
I haven't thought about it.
Yeah.
I mean, I guess in some sense, since the PTAB has been following the broadest reasonable interpretation standard, they've really moved it into a place that's probably purely a question of law. So in that sense, I would think that there's really going to be no deference. But then again, it's quite possible there might be a fact issue that gets fleshed out in the PTAB proceeding that would change that rule. So yeah, I don't know.
Yes, comment or question? Yes. Yeah.
Promote them.
Promoted, yeah.
Duffy would argue there's no difference between clearly erroneous and substantial evidence. That's probably true, but they are different standards. And so I'm not, they're making a mess of these things because they're not getting good.
So it's really Clem and Eliot's fault. Bad briefing.
Yeah, none of those have been my cases, by the way.
Yeah. Yes.
I just want to go back to stays for a moment. I guess this is a question for Judge Grewal mainly, but maybe some of the panelists could describe whether this affects us back. For docketing, collusion, big C or lower C, all that stuff aside, when you're looking at motions to stay, how much do you give the patents a sniff test? Do you ever think to yourself, like, I should grant the motion to stay here because, man, if the PTAB is definitely going to institute it and they're going to kill every single claim? So sometimes do you think this has got a really meaty one-on-one issue, we can just kill it now? I mean, I'm just curious whether or not you take a gander at whether you think the patent's going to be invalidated as to whether to grant motions to stay. And I guess the question for the rest of the panel is that something that you try to impress upon judges yourselves when you're making it?
Well, in any situation where I'm considering a stay of the case, whether it's a patent case, frankly, or any other kind of case, it seems to me I am obligated to consider the likelihood of success, in the parallel or higher proceeding. So, yes, I do think about the likelihood that the argument will carry weight wherever it may be going. Having said that, am I sitting there doing a meta trial in my own brain, trying to figure out whether or not this argument has true legs, particularly where, candidly, am I getting any briefing on that question? Oftentimes, no. So if it's a 101 question, that's a situation where I have reasonable confidence that I can look at the patent, perform the sniff as you describe it, and at least have some clue as to what's going on and whether or not this argument's likely to have legs. But you get into 102, 103, I've got a 20 or 15-page brief on the various factors. There's no discussion of intrinsic evidence. I haven't even construed the claims yet. I would like to be that man. I'm not.
And I was going to say, it seems to me that this is really only, again, useful in a situation, or it's going to be most useful to give the judge that in a situation where there's been no institution decision. If there's been an institution decision, there's already been somebody who's looked at it and made a determination about likelihood of success. So if you have a situation where you're prior to an institution decision, as I mentioned at the beginning, that's the situation I think this would be most powerful in, and I actually think that this is a better tool for plaintiffs than it is for defendants, because there's a huge cognitive load to go in there and say, Your Honor, here's the claims, and maybe there's 36 claims that have been asserted, and let me show you how all of these things are invalid and why this is likely to die in the PTO and why I'm likely to be successful. That's a heavy lift because the judge has got a lot of work on his plate already, and now you're trying to ask him to sort of do a substantive evaluation of the patent, where the plaintiff can come in and say, well, look, Your Honor, I just want to focus your attention on this one thing, which is missing from the prior art, or the reason that these two things wouldn't combine. And so I think structurally, I think it's a very powerful tool for plaintiffs to resist motions to stay, although I don't see them making it all that much.
And I think the rule may be different with covered business method patents. I think that once there's been institution, the court is not allowed to look second guess. Yeah. So different rules.
That's fair.
Are there any other questions? We've almost run out of time.
So I want to make one quick comment, and Mark will hopefully not shoot me. So we know in a case that actually we were against Mark. We seem to be against everybody these days. I think Mark and Clement. So we know that there's no appeal, interlocutory appeal from IPR, grants or denials of stay. So you have to take a writ of mandamus, and good luck with that. From covered business method patent reviews, we now know from a very recent Federal Circuit case, the IV versus JP Morgan Chase, that this is one of these great things, while you are fully free to move for a stay before institution, you don't have neither side, whether it's granted or denied, there's no right of appeal. Because the right to appeal doesn't attach until there's an institution decision.
So I would just say that is the law right at this moment. Stay tuned.
Thank you, panelists.